So I know I said yesterday that I was well and truly ready to take a break from Maddie's case, but then I figured a lot of people probably want to know what was actually contained in that plea agreement. So what I'm going to do in this video is read through the plea agreement, or at least the relevant parts. There's a few paragraphs that I will acknowledge, but I'll skip over because basically they don't apply to this particular case. Before I jump into that, I do want to just say a huge thank you to all the people who have given me super thanks and for the buy me a coffees. I feel a bit humbled by the amount of support I was given. I know I made the shout out in yesterday's video because of all my videos the last week pretty much being demonetized. And I really wasn't expecting quite as much of a flood of support as what I actually received. So thank you so much for your support. Now, if you are new to my channel, best way you can help me out is by clicking like and leaving a comment. Now, I realised this morning I am behind with uploading documents onto my Patreon, so I will make that my goal for this week. I'll do a bit of a catch up and upload as many documents as I can for you from this case. The documents that I'm going through today, plus a few other ones that are post-conviction, I will also add them to Patreon. If you are new to my channel and you're not familiar with my Patreon, I don't charge membership for my Patreon. There is a $1 tier and a $2 tier should you wish to just support my channel in that way. But if you're just wanting to get hold of documents and want to do so for free, then my Patreon is free to join. You just need an email address and you can join, and then all my uploads are free. So there is a bunch of documents on there already from this case. There is also a few documents from other cases. There will of course be documents occurring for the case of Leo Escalante, also for Sarah Grace, and hopefully down the track for Madalena Kojikari, because now that we have reached a resolution with Maddie's case, I will be able to start focusing a bit more on some of these other cases. So there will be more documents popping up on my Patreon related to other cases. I'm also quite interested in the Anthony Todd case, so I plan on doing a documentary style video on that. So just a long form video on that case in the near future. Obviously there's a lot of research to do beforehand, but I will be working on that, and when I finish working on that I will be uploading the documents that I have relating to that case. It's certainly a doozy. So if you are interested in joining my Patreon, the link for that is in the description section for this video. So let's move on and talk about this plea agreement. So they've basically started putting various documents now on the case docket for Stearns. So they're now readily available, most of them. I haven't had a chat with Paula to see if she's still going ahead with FOIA requests, but if she's not planning on doing so, I will do so, because there are certain things that I'm interested in viewing and things that I'm sure you guys would be interested in also. So I will keep track of what's going on in terms of FOIA. In terms of where Stefan is at the moment, he is currently in the reception centre, and we can expect to see him sitting there for anywhere between a week to 2 weeks. So we won't know where they're sending him for a little while. Now, in terms of that, I've heard that a creator has been claiming to have been in contact with Stefan since the plea hearing, and making claims about what he's said and all that sort of stuff. So I probably need to point out to you that the first however many days that he's in reception, he's not going to have the access to emails, to messages, to phone, etc. because he is transferred to a new place. So they're not going to have him set up for sending out emails, at least for several days. Likewise, commissary, he's not going to be set up to put in orders for commissary until all his paperwork is through in the location where he is at. Meaning that this person claiming to have had communication with him the evening of the same day that he was sent to the reception centre, that is a complete utter load of BS. Because they would not have set that up for him in that period of time. They still would have been going through all the rigmarole of actually just getting him checked in, getting him booked in, getting him into a cell. That sort of stuff, that's going to be bottom of the list. Now, I probably should mention also, I'll just clarify ahead of time, I may slip up and refer to remand centres because that's what we call them in Australia. I'm trying to get my brain to call it a reception centre, but if you hear me talk about a remand centre, it's the same thing. It's just my brain short-circuiting and going into Aussie mode. It's like when I talk about being in the bush, means like in the woods, but my brain cannot. That one's even harder for me to translate and refer to being in the woods, because to me, it's in the bush or up the bush. Anyway, that's not hugely important, but I just did want to clarify for people because I know that some people love spreading their stories, and I can assure you there would not have been any correspondence from Stearns within at least the first 24 hours of him landing in that reception centre. Anyway, let's move on and have a look at the documents. So there's a few documents that I'm going to share with you in this video. The main one, of course, is the plea hearing, which includes the addendum to the plea hearing, which you heard mentioned in court. I also want to go through the sentencing document, and I thought it was interesting to look at the score sheet that they were talking about. So let's just jump straight in first and have a look at this plea deal. And yes, apparently Amira is super tired this afternoon. That is her, once again, snoring her little heart out. Probably also doesn't help that for some reason her and the pup have swapped beds, and so she's in a bed that's actually too small for her and has her head hanging over the edge. So first of all, as you can see, this is our plea form. I, Stephen Stearns, defendant, withdraw my plea of not guilty and enter pleas of count 1, nolo contendere, to first degree M, for which of course the maximum sentence is life or death and the minimum is life. And as you know by now, the nolo contendere basically means no contest, where he's essentially saying he's not going to plead guilty, but he's going to accept the facts of the case. And something that occurred to me this morning and has got me wondering is the original charge was premeditated. And I'm wondering if perhaps prosecution could have got a guilty plea had they actually dropped the premeditated part. Because we know that for him, that was a bone of contention. And then moving down the page, we have the prosecutor has recommended the following. AG, Not sure what that means. Life without parole, CC, concurrent with 24 CF 632, as noted in plea addendum. Penalties. I understand the total maximum penalties for the crimes to be death plus total maximum fines of, doesn't say, and restitution. And then you've got his initials. Point 4, trial rights. I understand that if the court accepts my plea, I give up my right to a trial by jury, to have a jury determine whether I am guilty or not guilty, to see and hear the witness testify and to have my attorneys question them for me, for subpoena and present witnesses and items of evidence in my defence, and to present any defence I may have to the jury, also to testify or to remain silent, and require the prosecutor to prove my guilt by admissible evidence beyond a reasonable doubt before I can be found guilty. Essentially, he's giving up his rights to anything to do with a trial. So as you can see, the first part of this plea agreement is a boilerplate agreement. So there will be bits where we just go, yeah, we'll skip that. 5, plea understanding. I understand that a plea of guilty admits that I committed the crimes, and a plea of nolo contendere says that I do not contest the evidence against me. I understand that if the court accepts my pleas, there will be no trial and the court will impose sentences based on my pleas. Paragraph 6. Charges, defences, penalties. I have read the information indictment in this case and I understand the charges to which I enter my pleas. I have reviewed the evidence against me. I know of no physical evidence containing DNA which could exonerate me. My attorneys have explained to me the maximum penalties for the charges, the essential elements of the crimes and possible defences to the crimes. I understand these things. I also understand that if I'm on probation, community control, parole, that they'll be revoked, which is totally irrelevant to him. But if someone already had charges that were, they were on parole for, and they got subsequent charges for something and entered a plea agreement and entered a guilty plea, then, yeah, all that is off the table. Paragraph 7. Voluntariness. No one has pressured, forced, threatened or coerced me to enter the pleas. I am entering the pleas because I believe I am guilty or I believe that it is in my best interest. So he's ticked here that he believes it's in his best interest. He does not believe he's guilty. I enter the pleas voluntarily of my own free will. Why doesn't it surprise me in the least for him to tick the second box? I believe it's in my best interest. Deportation. Geez, I'd like to do some digging and somehow find a way to get him deported. I understand that that if I am not a citizen of the United States, I will be deported. I've also had a meaningful opportunity to consult with an attorney regarding deportation. Yeah, okay, but whatever with that. Education. The highest grade education I have completed, 12th. And I'm certainly not bashing anyone who has not gone further than high school, but for Stefan, that is great that it is here on paper to see because he is so certain of how brilliant he is. And yet he never ever went to college. I read and write English, which is, whatever. And then you've got a section there for if someone had it read to them. 10. Competency. At the present time, I am not under the influence of any drugs, alcohol, medication or narcotics. I am not presently taking any medication. I am presently taking the following medication, NA. Does not affect ability. Well, it doesn't because he says he's not taking any. I'm not suffering from any physical or mental problems that would affect my understanding of these proceedings. Enhanced sentence. I understand that the state of Florida is not seeking an enhanced sentence. Prisoner release, reoffender, which is not really relevant whatsoever. Criminal Punishment Code. I understand that my sentence will be imposed pursuant to Florida law and the Criminal Punishment Code score sheet, which I'll go through for you later on. This will be prepared and is based upon the offences that I'm entering pleas and my prior criminal record. I understand that I will not be permitted to withdraw my pleas if the correct score at my sentencing is other than what is presumed at this time. I understand that the score only suggests a minimum sentence and the court can sentence me to any lawful sentence. I understand that if my total sentence points are greater than or equal to 363, keep that in mind because the score is much greater. A life sentence may be imposed by the court for any felony offence. I understand that my maximum sentence is up to the statutory maximum unless the lowest permissible prison sentence in months exceeds the statutory maximum. No one has promised me that the court will depart from the scoring. Time served. I agree the correct amount of time served that I am entitled to is, and that probably should have been scored here, but it comes down to something like 505 days. So he probably shouldn't even have initialed that. 15. Early release. I understand that I may serve every day of my sentence. No one has promised that I will be released prior to the expiration of my sentence, nor that I will receive any good and gain time. In other words, there was no deal on the table in terms of giving him any time off. Thank heavens. Attorney fees. I do not waive my right to a hearing. I do waive my right to a hearing, and I agree that $100 is a reasonable sum to pay for the services of my court-appointed attorney. Sigh. Civil commitment. I understand that if I am entering a plea of guilty or nolo contendere to a S-motivated offence, or if I've been previously convicted of one, this plea may subject me to involuntary civil commitment as a S-violent predator upon completion of my sentence. Again, not relevant because he's not ever getting out. Likewise, driver's licence, so we don't need to look at that. Supervision, tolling and costs. I understand that while I am incarcerated, my probation community control parole is tolled unless ordered otherwise by the court. I understand that if I am placed on probation community parole, I will be required to pay costs of supervision, which is also totally irrelevant. 20. DNA. I understand that the court will order me to submit to a DNA sample. Sentencing date. Irrelevant because the sentencing was then and he wasn't going to be free at any point in time. Collections court. I understand that if my financial obligations are referred to the collections court program for collection, that any failure to comply with the collection court program requirements will result in the suspension of my driving privilege. Totally irrelevant again. Hearing presence. I do not waive my right to be present at any restitution attorney's fee costing hearing. 24. Seal expungement. No one has promised me this case will be sealed or expunged. Appeal. I understand that I have 30 days to file an appeal in writing of the court's judgment and sentence to the clerk of court. I wish someone would go through this document and fix it up. I understand that if I cannot afford an attorney, one will be appointed to represent me. My attorneys have explained to me that what an appeal is. By entering this plea, I understand that I give up my right to appeal all matters except the legality of my sentence. 2, this court's authority to hear this case, and 3, any pre-trial ruling for which I have reserved the right to appeal, and for which this court has made finding that controls an issue in this case. Most of that is somewhat irrelevant. The only thing there is that he can appeal if he doesn't like the judge's sentence. But given that it was in part of the agreement, essentially if he chooses to do that, they would basically mean that the case was back on the table. So we'd be back where we started. So he's not going to do that. Defendant's certification. I have read every word in this plea form, have discussed the contents with my attorneys and fully understand it. I am fully satisfied with the way my attorney have handled this case for me. My attorneys have done everything I have asked him or her to do. So that was the standard boilerplate bit. But this is the part that was referred to in court without really being made clear. And there's one bit that I hadn't picked up on, which part of me is a little bit frustrated over, but at the same time, I guess at the end of the day, he's still got that sentence. So this is the addendum to plea form. This is basically the part of the whole plea arrangement that was tailored specifically to this case. So you'll notice with all this that Elizabeth Burden has her hand in this. So up until now it was always Alicia Smith and Alex Johnson. But we have Elizabeth Burden in this. And I'm wondering if because of her seniority she may have been, pushing her weight around a little bit. That's just a bit of speculation. The Assistant State Attorneys, Danielle Marie Pennell and William Robert J., and the defendants, Stephen Michael Stearns, as well as his lawyers, Elizabeth E. Burden, Lizzie Borden, and Alicia C. Smith, agree to all the conditions outlined in this addendum to plea form and incorporate them into the plea agreement for these two cases. The defendant will enter a plea of guilty to counts 1 to 20 in 49/2024 CF 000632. In other words, the first case, the CSAM one. The defendant will be sentenced to life in the Department of Corrections on all 20 counts, and the sentences will run concurrently to each other as well as concurrently to the sentence in 49/2024 CF 001293. Now, paragraph 2 is the bit that I hadn't picked up on. It's possibly just because, I was watching this at 3:30 in the morning. So maybe you guys are going to go, yeah, we heard that. In exchange for the plea of guilty on counts 1 to 20, the state will enter a nolle prosequi on counts 21 to 60. So a nolle prosequi, which I know I'm butchering, basically means that they're not going to proceed further with the prosecution of those counts. So it's essentially throwing those counts out, but not entirely, because basically what it means, although there is a clause later on which kind of, provided that he sticks with the plea agreement, does protect him, but essentially a nolle prosequi it's not an acquittal. It doesn't get rid of those charges. They don't vanish. It just means that they are not prosecuted. However, because it's not an acquittal, it's not a double jeopardy arrangement. So he could, at a later date, be indicted for those charges. They have, like I said, got a clause further on in this agreement which protects him from that. That is, if he does stick with this agreement. So if he does not stick with the agreement, that means those charges go straight back on the table. So he's actually only received 20 charges instead of the proposed 60 charges, because 40 charges were dropped. And I will go through, after I finish going through with this document, and show you which charges they were in particular. Okay. Furthermore, the state will file no additional charges against the defendant for any alleged SA regarding the named victim in counts 1 to 20, nor will the state file any additional charges regarding any child PN that was recovered in any county during the course of this investigation and prosecution. That basically is saying, I mean, they wouldn't be able to anyway, but all those 35,000 images that were on the thumb drive, they're basically saying even if they could prove a connection to him, they won't actually prosecute that. But as I've said from the beginning, and maybe Stearns just doesn't know this, but, you know, they wouldn't be able to prosecute those because they would not be able to prove the connection to him in a solid way, because the thumb drive was given to them by Chris Stearns, so it wasn't found through a search warrant amongst any of Stearns' property, Stefan's property. But not only that, because he destroyed the hard drive on his computer, then the best they would be able to do would be to link it to the IP address. And of course, you've got 3 people living at that address. So they would not, without the hard drive for his computer, they would never have been able to link those 35,000 images to Stearns in the first place. Because a good defence would turn around and say, well, you can't prove that they didn't belong to his father or his mother. And of course, as unlikely as that seems, they would only have to present the evidence of Chris Stearns' 15-year affair to create enough reasonable doubt. So obviously they are never going to push charges on those 35,000 images. But the main thing here is that this agreement basically means that they cannot turn around and refile for the 40 charges that have been dropped. Okay, moving on to paragraph 3. The defendant waives his right to file an appeal regarding the denial of any or all of the motions to suppress which were denied by the court on July 1st, 2025. Meaning, of course, that prior to this agreement, had he gone to trial and got a conviction, then he could have, one of his grounds for appeal could have been that the court denied those motions to have the phone evidence thrown out and to have the Google evidence thrown out. But by agreeing here to these terms, he can't appeal against that decision in any way whatsoever. Which is kind of a moot point anyway, because if he's going to plead guilty, then he really doesn't need to appeal that. 4. The defendant understands that by entering into a plea agreement with the state of Florida, the state will not be required to present witness testimony and the digital evidence to prove the allegations in the information filed against the defendant. Although the visual evidence would be presented in a manner that members of the public would not be able to view it, the defendant agrees that it is in his best interests not to have the testimony and evidence against him presented during a trial in a public courtroom. So that's just the acknowledgement that by making this plea, the world isn't going to see all those horrible images. which it protects Maddie. But obviously this is something of concern for him because this is something that his lawyers have stipulated as part of the agreement. So they're basically saying it's in his best interests that this is not presented in a public courtroom. So it seems that in denying the motion to have the phone evidence thrown out, that's where we get our guilty plea from in the first place. Let's go on to paragraph 5. The defendant will enter a plea of no contest to first degree. M. The defendant will be sentenced to life in the Department of Corrections, and the sentence shall run concurrently with the sentences in 49/2024 632. In exchange, the state will waive its notice of intent to seek the DP. Who gets a better deal there? In my opinion, I think that he should have had to enter a guilty plea. Both the defendant and the state understand that a sentence of death could not be given to the defendant unless there was a conviction for first-degree murder, an 8-4 jury recommendation for a death sentence, and the court would ultimately determine if a death sentence would be pronounced if the jury made a recommendation for a sentence of death. Which, we know there's nothing in that. The state and the homicide survivors have the benefit of the certainty of a conviction with a sentence of life in the Department of Corrections, as well as the finality of the relatively few options for post-conviction relief with a plea agreement. In turn, the defendant knows with certainty that he will not face a sentence of death. So essentially, this is like, this finalises it. You get no appeals after the 30-day grace period that you have, and in return for that, you get the certainty that you will not face a death penalty. The defendant acknowledges that all the documentary and digital evidence, barring unexpected supplementary discovery, has been provided to and reviewed by his team of attorneys. The defendant does not wish for any additional time to review or discuss this evidence with his team of attorneys. So basically, it's based on what you've seen of the evidence, what you've seen of documents and digital evidence, and you are acknowledging that you do not need additional time to look at that evidence. So he can't turn around 3 months down the track and say, but I didn't have enough time to look at the evidence and now I've found something. Now this is kind of another poorly written bit. The defendant understands that his attorneys may take depositions of all witnesses on the state's list, and he is satisfied and in agreement with the decision not to proceed with any additional depositions. So basically they're saying you can't turn around now and find another witness and get a deposition from them and say, well, hang on, I've just got this deposition here that is actually that's exculpatory and it's going to clear his name. Basically, that's off the table. So it's not saying that it recognises that they can still take depositions. It's saying that it recognises that as part of their job, that is what they do. But basically, that's it. There's no more depositions. So 10. The defendant understands that even if he does not wish for his attorneys to do so, they are obligated to prepare a mitigation case on his behalf for a potential sentencing phase at his murder trial. The defendant understands that by accepting this plea agreement, his attorneys will stop working on both defending his guilt phase for a trial on the M charge, as well as the sentencing phase. The defendant understands that the mitigation presented to the state thus far regarded an incident involving a car striking him as a child. So it's basically saying that, had he continued with this, then his attorneys would have had to have worked on presenting a mitigation case in the event that he was found guilty by a jury. But all that's now off the table. And that means that in terms of mitigation, his being run over by a car, sorry, I can't help snickering at that because it's just pathetic. He had concussion. That's all it was. But yeah, so basically it's saying, well, that mitigation means nothing now because the judge is not going to consider any mitigating circumstances in making his sentence. 11. The defendant understands that if he went to trial on either case, or both cases, he could appeal any errors he felt the court or the state committed during the trial or trials. However, by entering a plea and waiving his right to appeal the decisions on his 3 motions to suppress evidence, the only issues he can appeal are the legality of his sentence and the jurisdiction of the court over him. Meaning, if the sentence was harsher than is allowable by law, which obviously isn't, he could appeal that. And as for jurisdiction, if they've somehow put him into the wrong courtroom, and he should be in a different judiciary circuit, which we also know is not the case. The defendant understands that if he successfully moves to withdraw his plea and sentences, that the state's notice of intent to seek penalty, the DP, will be reinstated and he will proceed to trial on CF 1293, facing a potential sentence of death. The state's nolle prosequis on counts 21 to 60 will be nullified and he will proceed to trial on all 60 counts for 00632. And the state will be permitted to file any and all additional charges against him in any county in Florida where such charges may arise regarding any uncharged SA of the named victim in counts 1 to 20, as well as any additional child PN charges. Meaning, I think what they're saying there is, if you change your mind, not only do you get it all back, but you get it all back with a vengeance. We are going to hit you with even more charges, which suggests to me that just maybe they've got even more evidence that wasn't originally tabled in terms of charges. Maybe from when him and Jen were living down in, Port Charlotte. Maybe they have traced digital evidence further back. They could also be holding the thumb drives over his head, even though, like I said, that would be a pretty easy one to defend. And then the defendant understands that if he successfully finds any post-conviction relief on either or both cases, that all of the conditions outlined in paragraphs 12A, 12B and 12C will apply at the state's discretion. So in other words, if something happened and someone could suddenly prove that he was completely innocent of these charges, the ones that he's agreed to, then basically the things outlined in the previous point that I just went through could well be on the table. Meaning that they could throw additional charges at him. They could take him to trial for the M case, and they could also add back those additional 40 counts. So it wouldn't really be post-conviction relief, and I like that little clause there. So there were originally 3 types of charges for this first case. One was S, battery on a child under 12, and all those charges held and he was given a guilty verdict. The second one was S, battery with a child 12 to 18, familial custodial. Sorry, there were 4 different types of charges. So that one also held as guilty. The third type was the one which I will let you read for yourself, and I will just blow it up momentarily for you. So that's your counts 14 to 20, which I'm not going to read out because YouTube doesn't like words like that. So they also stay there as a guilty sentence. So the charges that were taken off the table, the 40 counts that were taken off the table, are all in relation to the images and the videos. So they're all gone. All those images and videos that he found, he's not actually prosecuted for them. That's your nolle prosequi, or prosequi, which part of me is a bit annoyed with that, because to me, obviously that is secondary to the acts that he was doing, but I think they should have at least kept half of those charges on the table, because it contributed to Maddie's humiliation. It was such a depraved act. So that, to me, is another failure by the prosecution and by the judge. He should have been found guilty of at least a portion of those charges. Like I said, sure, it's secondary to the acts, the physical acts that he was doing, but the fact that he was memorialising it, and now that he's not prosecuted, that hurts my soul so deeply. I really feel that Maddie has been betrayed by the prosecution and by the judge. And I know it makes no difference. He's still got 20 life sentences or 21 life sentences. But that's not the point. What he did was horrible, horrible. And those images should have never existed. And he should at least have had some prosecution for them. Sure, don't go with the 40 charges. I can appreciate that. Go with 10, go with 20. But don't drop all of them like this. That's such a betrayal of Maddie. Now I'm just going to skip through this score sheet pretty quickly, because I found it pretty fascinating, but it's not something that we want to read every single part of. So the way it's separated, it appears that they have to have a primary offence that is scored, and it looks like it is scored double to the other offences. So they've got SB with a child 12 to 18, and that's 92 points. And then you've got the other ones that are SB, same thing, but each of them only gains 46 points. So for one count, they've doubled the points by the looks of it. So basically down the bottom it lists supplemental page points. So basically, obviously there is your supplemental page which lists all the other 20 charges, and that brings it up to 506 points. And then you have section 3, which is victim injury, and I can't read the middle section, but the third part where he gets 280 points, it's 40 times 7, which gives him 280 points. It says S contact. The one that I can't read is 80 times 5 points, and that gives him 400 points, so that is a total of 680 points. And remember, he only needed 363 points to get a life sentence. So this is the supplementary page that's mentioned. Basically, he got 46 points for every single count. Now, I don't know how this formula is worked out, but at the top there you have a total sentence point of 1,278. So that is well above the 363. And then it's calculated. It has the 1,278 minus 28. Maybe it gets rounded down or up to the nearest 50, I'm not sure. 1,250 times 0.75, so 3/4 of the final score gives him 937, which is still well and truly over your 363. So that basically means that no matter which way you look at it, it's life. And then you've just got this judgment and sentence sheet, which just basically outlines everything I just said to you. So counts 1 to 8 were SB on a child under 12, capital offence. 9 to 13, SB with a child 12 to 18, as a familial or custodial authority. 14 to 20, the one that I can't read out. 25-year minimum sentence, but obviously gets life. And 21 to 60, which is what were dropped, unlawful possession of materials. And the bottom is just basically, again, outlining what the charges were. So counts 1 to 20, life. 21 to 60, noli prosequi. Adjudicated or adjudged guilty, 1 to 20. Minimum years, minimum mandatory 25, counts 14 to 20. And then you've got the sentence, life without parole. And 20 counts thereof. Although 21, I guess, if you count the M charge. All counts are concurrent, as we already know. And there's a whole bunch of things listed there that could have been conditions, but basically the only condition that was applied was that victim impact statements were read and put on the record. So he actually got a pretty damn good deal, if you ask me. Now, someone mentioned in the comments section that it seemed like an anticlimactic sentencing, and I agree. I felt that Judge Carson could have actually made a pretty strong statement to Stearns, but he didn't. The other thing that I was disappointed with, and like I said in yesterday's video, Grizzly was pleased because he got close to $12,000 in fines, which is going to come out of his commissary, obviously, and that is going to hurt him for a while. Now, my concerns, which someone mentioned I don't need to be concerned about, were that maybe he would get half of his parents' estate when they passed. Turns out that he's not entitled to, because he is incarcerated. So that's a relief to know. And given that his brother wants to have nothing to do with the entire family, I would imagine that if his brother is the one that gets the estate, he's certainly not going to be continuing to put money into Stearns' commissary when Chris and Deb are gone. So that's reassuring to know that he won't have that little bit of money coming in down the track, and that he does have that bill over his head. But I mentioned yesterday that I didn't feel that it was a huge amount, because we are talking about a lifetime in prison. And the thing is, something that you see in so many cases is what happened with the Idaho 4 case. And that is, the judge has put some massive, massive fines on Kohberger. Now, he will never pay off those fines because he has to pay each of the families restitution of $5,000, I believe. And then for each of the counts, he has a $50,000 fine. So straight up, this guy already, before any of the other costs are incurred, straight up, Kohberger has a $220,000 debt. Why does the court do that, knowing that he cannot possibly ever pay that debt off? It basically prevents him from entering into any monetary agreements where someone offers to pay him for exclusive rights to a book or something. Because Kohberger, like Stearns, is in for life. And he's actually younger than Stearns. He's only 30. I mean, we're talking about people who could be potentially locked up for the next 40, 50 years. So this guarantees, with Kohberger, it guarantees that if he tries to make any deals to, make a book deal or a movie deal or something like that, the money goes into the state. He's not going to profit from his crimes. But for Stearns, if someone wanted to approach him and offer him money for a book deal or a movie deal, he could well make money from it. So I am really disappointed that he is only charged $11,000. Now, it'd be nice if someone hopped into the comments section and said, actually, there's a law in Florida that prevents him from actually getting monetary gain in that way. That would be a weight off for me. So if someone knows of something like that, let me know. But it does concern me that he only has an $11,000, $12,000 debt. Because when you look at the time frame that he's going to be in there, when you also look at Chris and Deb, I would half expect them to turn around and say, well, our money's not any good to us after we fall off the twig, and he's not going to get any of our money after we fall off the twig. Let's pay that debt now. Personally, I think they would be utterly deplorable human beings if they did do that. But we know that Deb Stearns still thinks the sun shines out of his arse. So we can't completely say, no, that would never happen. Because I think if Deb Stearns had her way and if she had full control over the money, she probably would pay that money. Anyway, I'm going to leave it at that. I do have other videos that I want to do about Maddie's case, but as I said yesterday, we're all ready for a break. I think we just need processing time now. But I did want to go through this particular document, the main document, because I know a lot of people were questioning what was the addendum. So that clarifies a few things for you. And it also clarifies for you that no, he's not writing emails to his best bud or to his parents at this current point in time, because that will not be set up, not at least for a few days at the earliest. So be careful what you believe from other content creators. So on that note, thanks for listening, and I will catch you in the next one.
sometimes